Hello students, I am Dr. Prashant Kumar, Assistant Professor, Department of Business Administration, Government Lohia College, Churu. Now you can see the title of this video, the Indian Contract Act 1872 Key Features. In this video, we will discuss about the Indian Contract Act 1872 in terms of nature of the contract act, or we can say the basic features of the Indian Contract Act may be discussed in this video. We will start this video uh, with the help of some points for discussing the nature of the Indian Contract Act 1872. So very first point is enforcement of the Indian Contract Act 1872. We are discussing about the enforcement of the act. The Indian Contract Act came into existence in the year of 1872 and the date was 1st September. We can say that the act came into force on 1st September 1872. The Indian Contract Act 1872 uh, is not retrospective in operation, and we can say that it is not applied to contracts entered into before its existence, or it means that before it came into force, it doesn't apply to such type of contracts. It means that the contracts entered into prior to 1st September 1872 and to be performed after passing of this act, it it is not applicable to such type of contracts. So the enforcement of the act is related with the date of its existence, which was 1st September 1872. Now the second point is extension of the Indian Contract Act 1872. The extension of the Indian Contract Act 1872 um, with the connection to the whole of India except the state of Jammu and Kashmir. So, if you want to if you want to say something about the extension of the Indian Contract Act 1872, then you should speak that it extends to the whole of India, except the state of Jammu and Kashmir. Now, the third point is application of the Indian Contract Act or applicability of the Act. Uh, we are discussing about the Indian Contract Act 1872. The act applies to all contracts in India. It means all contracts are covered under the regime of the Indian Contract Act 1872, but it doesn't deal with the place where contract is made. And the provisions of the Indian Contract Act 1872 applies both Hindus and Mohammedans, and these provisions uh, override the provisions of the Hindu law and the Mohammedan law. In case any dispute arises, we can say that uh, the Indian Contract Act 1872 override the provisions of the Hindu law and the Mohammedan law. So we can say that uh, many legal interventions were many legal interventions are derived in case of English law. Then we can say that the Contract Act deals with the point that the English law on that point is not relevant. Now, the fourth point is the Indian Contract Act is not complete and exhaustive. It means there is a chance to amend. As we all know that many acts are amended by time to time, according to the situation, according to the government decisions, according to the legal decisions. Similarly, the act in the Indian Contract Act 1872 is not complete and exhaustive. It contains certain general principles of the law of contracts, along with the laws to some specific contracts. It has some general principles regarding contract proposal, agreement, breach of contract, performance of contract. Likewise, uh, it had some principles and discussions about specific contracts like quasi contract, indemnity contract, guarantee contract, bailment contract, place contract, and agency contract. And the Indian Contract Act is not in corporate law relating to all kind of contracts. It means if we talk about the laws relating to sale of goods, law relating to partnerships, law relating to negotiable instruments act, negotiable instruments like check, promissory note, likewise transfer of property, likewise insurance. These are not incorporated in it. We can say that the all these relating all these relating kind of contracts are not incorporated in it. Separate acts have been enacted for dealing such type of specific contracts. Uh, we will discuss these separate acts in separate videos. Uh, so let's let's discuss about the preamble of the Contract Act. The preamble of the Contract Act 1872 provides that this act provides and amends certain parts of the law relating to contracts. It means that the statutes, acts, and regulations not amended or repealed remain unaffected by the provisions of this act. So we can say if any custom of trade or any usage or is not inconsistent with the provisions of this act, it means it remain unaffected. Mm. Furthermore, we can say that where the cases are not covered either in Contract Act or by any other specific act relating to the contract, the provisions of Hindu law for Hindus and Mohammedan law to Mohammedans are applied. Um, uh, Similarly, we can say that it is also adaptable to English law in such a way if the situation is inconsistent in terms of justice, good conscience, and equity. So the all the laws and customs of trade not inconsistent with the provisions of the Contract Act, it means it remain unaffected and are allowed to prevail uh, with the help of provision in the Contract Act. Now the fourth point is over, and we will start fifth point. in terms of nature of the act or key features. The Contract Act, or we can say the Indian Contract Act 1872, uh, has 266 sections, and we can say that it is divided into 11 chapters. But in the year of 1930, the provisions relating to the sale of goods, and the year 1932, the provisions relating to partnership were repealed from this act. This act means the Indian Contract Act 1872. The Indian law relating to contracts is now we known as the Indian Contract Act 1872. If we talk about Indian Contract Act 1872 in terms of total sections and total chapters, then we can say that it has basically it has 266 sections divided into 11 chapters. But in the year of 1930 and in the year of 1932, uh, the provisions relating to sale of goods and provisions relating to partnership were repealed from this act, and uh, the specific separate acts related to sale of goods and related to partnership act were enacted. As we all know, the Sale of Goods Act 1930 and the Partnership Act 1932 uh, are in the shape of separate acts. So, presently, the Contract Act or the Indian Contract Act has 238 sections. 238 sections. Section 1 to 75 is related with general principles of the law of contracts and quasi contracts, and there are some separate sections. If we talk about some separate sections, the certain special kinds of contracts like indemnity and guarantee is described in section 124 to 147. Bailment and plays are in section 148 to 181, and the agency from section 182 to 238. So the sections uh, f- related with the general principles of the law of contracts and quasi contracts are from section 1 to 75, and the sections 1 to 75 of the Indian Contract Act are useful in the condition of general principles of the law of contracts and quasi contracts. And if we want to know about the indemnity and guarantee, then we should go with section 124 to 147. And if we want to know about bailment and plays, then we will go to 148 to 181. And if we want to know about agency contract, then we will help, we will help of sections from 182 to 238. So the Indian Contract Act has certain principles of law of contracts within which the parties are allowed to create their own legal rights uh, under the Indian Contract Act 1872. We can say that if a contract is made in accordance with the provisions of the Indian Contract Act, but the uh, legal scenario is different in terms of the parties created by a contract are enforceable by action against the party in default. In such cases, we can say that the parties are free to make their own terms and conditions of a contract, but it is subject to the provisions of the law of the land. It means if like the uh, we live in India, so the provisions of the law of the India are applicable to each and every term and condition of a contract. Uh, Now the turn is for sixth point. Sixth point is it creates right in personam. It means there are two type of rights available to a person. Any person having two type of rights. Number one right is in we can say right in personam or just in personam, and the second right is rights in rem. So the right in personam means a right against a particular person. If you have a right against a particular person, then you can say that you have a right in personam, and the right in rem implies a right available to a person against the whole world. If you say that you have right against the whole world, then you can say that the right is rem. And if you say that you have right against a particular person, then you can say that the right in personam. So there are two type of rights, and the rights created by a contract are purely personal in nature and only enforceable by the action uh, related to the party. So the if we talk about Indian Contract Act 1872, and if we talk about the contract situation as per the Indian Contract Act 1872, then the right in personam, or you can say you have a right against a particular person or persons, then it is embodied in the Indian Contract Act 1872. Uh, I think I should give a example or for better understanding this term. For example, Amit sells his car to Sumit uh, for 2 lakh. Listen carefully. Amit sells his car to Sumit for 2 lakh, and Amit has a right to recover the price of the car from Sumit. So the right of Amit is a right in personam because it is related with a particular person. Particular person here is here the Sumit is a particular person. So this type of right is right in personam. Okay. Likewise, I think I should give another example. Uh, okay, let's start with another example. Uh, for example, Sumit buys a car and becomes the owner of the car. In this type of situation, Sumit has a right to have quit possession of the car uh, against the whole world, because Sumit buys a car and becomes the owner of the car. Nobody in the world can disturb in his such right, because the right of B is just in RAM. The right of Sumit is just in RAM. It means the right against the whole world. So I think these examples are sufficient for better understanding. Now in this video we can summarize 2 points, so that the objective for making this video should be fulfilled. We will discuss about the scope of law of contracts. The scope of law of contracts uh, is described into 2 points. If we talk about the scope of law of contracts, earlier I have talked about the Indian Contract Act's key features, nature of the contract, but now I am trying to analyze the scope of law of contracts. So listen carefully. The law of contracts is not the whole law of agreements. There are two statements specifies the scope of law of contracts. First is the law of contracts is not the whole law of agreements, and the second one is it is not the whole law of obligations. It means that the law of contracts is not the whole law of agreements. uh, if we talk about this situation or this statement, uh, I'm using a statement of uh, Justice Salmond. Justice Salmond said that the law of contracts is not the whole law of agreements, nor it is the whole law of obligations. It is the law of those agreements which create obligations, and of those obligations which have their source in agreements. It means the law of contracts is not the whole law of obligations. Uh, I'm trying to analyze these type of situations uh, with the help of some um, legal aspects. Uh, I can say that it is also true that the legal obligations are from voluntary agreements. Legal obligations may also arise like tort or civil wrongs, likewise judgments of law courts and the statutes or relationship, like husband and wife relationship, trustees and beneficiaries relationship. Then legal obligations may also arise. The law of contracts is concerned only with the obligations which have source in voluntary agreements, voluntary civil agreements. We can say that if we are in the situation of voluntary civil agreements, the law of contracts, it means the Indian Contract Act 1872 applies to these type of conditions. But in the situation of legal obligations, according to the Justice Salmond, the law of contracts is the law of those obligations which have their source in agreements. The obligations which arise from any other source are not the subject matter of the law of contracts. We can say that such obligations are subject to their respective laws if enacted, if available. So the law of contracts is not the whole law of obligations. It means there may be some separate situations like tort or civil wrongs. There may be judgments of law courts. There may be specific status or relationships like husband and wife, trustees and beneficiaries. Then the situation is totally different. uh, so now the time is over for this video. We will meet again. Thank you very much, dear students. Thank you for listening carefully. Thanks.